This small claims case looked ordinary on the surface. Two people walked into a courtroom believing they were right. Both believed their version of the story would be enough. But in small claims court, belief does not decide cases. Details do. This story took place in a small claims court in the United States, where judges hear dozens of cases every single day. Judges do not have time for long speeches or emotional arguments. They listen for one thing only, and that is proof. The plaintiff was an everyday working American who had filed the case to recover money he believed he was owed. He felt confident because he trusted his memory of what was agreed upon. He believed honesty alone would carry him through. The defendant entered the courtroom with a calm and composed attitude. He believed the case was weak and that the plaintiff could not clearly prove his claims. He did not argue emotionally, and he did not interrupt. The courtroom was quiet and formal. Both parties stood before the judge, aware that everything they said mattered. The judge looked over the file and allowed the plaintiff to speak first. The plaintiff explained his story carefully. He described how the agreement was made and how he felt misled. He spoke with conviction and expected the judge to understand. The defendant then shared his version of events. He disagreed with the plaintiff but remained calm. At that point, both explanations sounded reasonable. Then something changed. The judge raised a hand and stopped the conversation. The room went silent. The judge leaned forward and focused on a single detail that had not yet been addressed. The judge asked one simple question. He asked exactly when the agreement was made and whether there was any written proof confirming the terms. It was not a complicated question, but it was a decisive one. The plaintiff hesitated. He tried to explain verbally and fill in the gaps with memory. He admitted that most of the agreement was verbal and that he did not bring written documentation. The judge listened without interruption. Then he turned toward the defendant and asked the same question. The defendant responded confidently and clearly. He presented a dated message and a written record that showed different terms than what the plaintiff claimed. The evidence was short, simple, and direct. In that moment, the entire case shifted. The judge no longer needed long explanations or emotional arguments. The answer to one question had already decided the outcome. The judge explained that small claims court is based on evidence, not assumptions. He stated that verbal agreements are difficult to enforce without proof. He reminded both parties that documentation protects everyone. The judge then delivered his ruling. He ruled in favor of the defendant. The decision was not personal and it was not emotional. It was based entirely on the evidence presented. The plaintiff stood quietly, realizing where the case was lost. The defendant respectfully gathered his papers. The hearing was over. This story carries a powerful lesson for anyone in the United States considering small claims court. Confidence does not win cases. Preparation does. One question from a judge can expose the weakest point in any claim. That is why understanding what judges look for matters more than telling a convincing story. In small claims court, small details decide everything.